All right, well, good morning. Appreciate you joining us today. My name is Chris Nagel, and I'm joined with my colleague, Kelsey Hayes. We're both at the law firm Holland Knight, and we do government contracts law here. And we have a monthly webinar where we present topics of interest to government contractors. This month's topic is compliance programs, strategies, and requirements. And as I said, we both do government contracts work. We probably spend maybe 60 or 70% of our time on litigation related issues, and that includes a lot of enforcement action. And then the other 30 to 40% of our time we spend on counseling, and that includes a lot of compliance work. And so the hope is we can bring both of those sets of experiences to bear here and provide some valuable information with some practical takeaways for folks. Here's me, here's Kelsey. Here's our agenda for the day. The way we usually handle these is I will kind of set the stage and talk about this at a high level, and then we'll ask Kelsey to dive into the weeds of some of the specific regulatory requirements and DOJ publications and case law and things that we think might be applicable and relevant to the topic. So with that, let's start off with our first topic, which is who cares? Why does this matter? I suspect that if you've decided to spend an hour of your day with us talking about government contracts compliance, you probably have a pretty good handle on why it's important. But we're nevertheless going to set the stage with that, and hopefully it'll be helpful for you and also maybe for others within your organization. Obviously, all organizations have limited resources, and sometimes it can be tough to get the attention of decision makers in terms of why this is important and what specific steps need to be taken. So if you're already on board with this idea, then the hope is it'll be something useful within the organization that you can share with others in terms of why we may need to commit more resources to it if you don't have a plan that you think is going to make sense for now. So Kelsey, maybe I can turn it over to you to talk about some of the high-level risks and issues faced by government contractors that we don't see in the commercial world, that the same company offering the same services to a commercial customer wouldn't necessarily have to face.
Absolutely. So I think that's a good way to look at it. So we're not talking about being in the commercial space. This is specifically when you're getting into government contracts, how the landscape changes. And so a good place to start, in my opinion, is what it says in the FAR at the very beginning. So the FAR provides that government contractors must conduct themselves with the highest degree of integrity and honesty. The FAR talks about how government business must be conducted in a manner above reproach. And why is this? It's because when you're performing work for the government, the government is spending taxpayer funds to procure the goods or services that the government needs to function. And so there's a heightened scrutiny and awareness when public funds, taxpayer dollars are going to government contractors, going to these businesses. And so the regulations require, a heightened ethics standard and a real, careful attention to, business ethics, compliance, and just ensuring that everything is sort of above board, so to speak. So these principles are talked about in the FAR, specifically FAR Part 3. And that's the beginning, the standpoint from where kind of I think all of this, all of the compliance and regulatory obligations that we're going to talk about today flows from. And it's with that said too, the government has a bunch of tools at its disposal to kind of ensure that these, this highest level of conduct is adhered to and followed by both government contractors and government employees that are involved in the procurement process.
Yeah, so I think most companies that we work with at least have a general sense of wanting to be a good corporate citizen and just sort of do the right thing in the abstract. But as we all know, working with the federal government, there's some really specific sticks the federal government has to enforce that in a more practical and tangible way than you see in other industries, where the worst you likely will face with your customers is a lawsuit for a breach of contract. By contrast with the government, this is among the list of sort of terrible things that can happen and that can stem directly from a lack of focus in the compliance area. And we won't read through each one of them, but I'll just focus on the first one, which is probably the biggest one that we see in terms of a nuclear button that the government sometimes pushes, which is the False Claims Act. Obviously, that captures a situation where a contractor submits an invoice that it is knowingly for work it didn't do, or for services or goods it didn't provide. But as most of the attendees probably know, the False Claims Act has been expanded in the last decade or so to include this idea of implied certification. So not only are you certifying that you delivered the goods or services that's encapsulated in the invoice that you submit to the government, you also now, as of 2018, with the Supreme Court's decision in the Escobar case, you're now also certifying, impliedly, but nevertheless certifying, that you're in compliance with all material terms of the contract. So what used to be, or what may seem like a simple contract administration function, now suddenly becomes a False Claims Act issue, which the government can bring, or a whistleblower, by the way, can bring. And there's no qualifications for the whistleblower. It oftentimes is somebody with maybe an interpersonal axe to grind with the company. But for whatever reason, the whistleblower chooses to bring a False Claims Act. It can come from outside the government as well as inside the government. It can lead to treble damages, 3 times the damages that the government incurred, which oftentimes, if it's a fundamental term in the contract, can be 3 times the value of the contract. So these things end up being usually at least 6 figures, oftentimes 7, 8, 9 figures, which we'll look at in terms of settlement amount, plus the fine on top of it, plus the reputational damage, not to mention the legal fees that are incurred. And so, I had a law partner who used to say his clients who called him every day were his favorite clients. The clients who waited until something went wrong were the clients who paid his mortgage. And the same is true here with compliance, is that there's an aspect of this that is prevention, where we hope to avoid this. And let's look at some recent headlines. I don't think we need to spend a ton of time on this, Kelsey, but suffice it to say, these are contractors just in the last year who are settling for tens of millions of dollars. It probably also has a tail of several years behind it with the legal fees that go along with that. And it's across the board for anything from the types of bids that were submitted to small business representations. And so these are all things that we typically address through a compliance program. And so it's underscoring what we're trying to avoid. And as we'll talk about in a minute, it's also underscoring the types of things we can do if an issue like this comes up to try to mitigate it. So you'll see I added a few slides in here. Kelsey did a great job putting this together. And in a former life, I was in the Marine Corps. So you'll see a couple of really simple, direct, basic slides that are easy to understand for folks like us that need it. In my mind, at least, this is not captured in statute or regulation anywhere, but at least in my mind, when we're talking about this, why does it matter? Who cares? It's because, number one, it's to avoid that bad stuff we just talked about. It's to avoid all this list of compliance and enforcement actions that the government can take, things that can lead to companies, at the very least, having a bad year. At worst, shuttering and literally going into bankruptcy. These are the things that end up in the C-suite and shareholder reports and people losing their jobs. So we're trying to avoid that with our compliance program, right? Make sure those things don't happen. Those things still happen to the best of companies, to those that are the best corporate citizens and truly have the best intentions. And so the second idea here is, if we have an issue like this with one or several employees, or there's an unwitting step on a landmine, how do we minimize that damage? How do we avoid being these companies who went all the way down the road with the False Claims Act, more than likely ended up getting debarred from government contracting, which can, in some instances, be even worse than the False Claims Act money that you pay out, is that you're no longer allowed to compete for new government work as it's issued for a period of years as a result of this, I mean, that can actually shutter a company, and depending on how reliant the company is on federal work. So this is where we're trying to go, is how do we best avoid the enforcement issues, and how do we minimize the damage if something comes up? And so I will say for most attorneys who do CLE, who do continuing legal education, who need that for their state, I know we have a lot of those on the line today. I've been known to check out a little bit and multitask during these things. So I'm going to lay out up front what the three, this is a very high level checklist. But if you're going to multitask, stop for a minute and let me give you the 3 points that I want you to go back and check your compliance program and see if you have these three things written out and in a clear and easy to communicate way, so that if there is an issue down the road, we know what the government's going to ask for, and that's these three things. So if you look at the Federal Acquisition Regulation, the FAR, and you look at the DOJ sentencing guidelines, you can get a really clear look at what the government will expect to see in a situation like this. I think it also helps with the first point of avoiding. I think it's a good best practice to avoid kind of the enforcement action. But if you have one, we know what's going to be on the test. It's going to be these three things. It's going to be a written code. It's going to be what I'm calling employee training to capture that concept, and then an internal control system. So if you can't right now go back and find documented memorialization of these three things, then I think that's the place to start. And we're going to spend the rest of the hour here going through each one of these three topics in some level of detail, but I wanted to make sure that before we got off the ground, we know where we're trying to go, and you can at least have this as a takeaway to go back. And if you've got this written out, we'll talk about some practical maybe ways that you can improve it, but at least you've got kind of that first leg of we know what the government's going to ask for, and we're ready to provide it. As long as I've got everybody's attention, and before we delve into the details, I'm also going to take this opportunity to read off the code for, I think it's just New York attorneys, but if anybody needs a code for live attendance, I'm going to do that now before I forget. That code is HK for Holland and Knight. So HK Hotel Kilo, HK 2304284368. I'll read it one more time. HK 2304284368. And I think our marketing folks will also post that in the chat, I believe. We will also keep an eye on the Q&A and try to answer them in real time if folks have questions, or we'll try to get a little bit of time at the end if we don't get to it when the question's submitted. All right, with that, let's dig into the details now. We're going to start by going through the first of those bullets that I had on the previous slide, which is the written code. Kelsey, can you walk us through what that is and the basics of what we need to have in the code?
Yes. So the written code, it stems from the FAR clause 52203-13, which is Contractor Code of Business Ethics and Conduct. So as Chris noted, the FAR requires, so if this clause appears in your contract, you are required to have a written code of business ethics and conduct. If it's in your contract, you're required to have it within 30 days after award, and you're required to make it available to each employee engaged in performance. Okay, well, what if it's not in my contract? That means, does it apply to me? Probably. So one, if it's in your contract, it definitely applies to you. Two, you should look at the FAR because it advises that contractors should have a written code of business ethics and conducts anyway, notwithstanding whether the FAR clause is actually in your contract. And three, because of the mandatory disclosure rule, which we'll talk about a little bit later on, you're required to, comply with the mandatory disclosure rule, notwithstanding whether you have the FAR clause in your contract or not. So the requirements stem from this FAR clause, and this is the framework that we're going to use to talk about the plan, especially because it is in fact required for some contractors. But even if it's not specifically required of you, this is where you should look to, and this is where you should go to build out your code of business ethics and conducts, your compliance program, and then the internal control systems that Chris was talking about on the last slide.
Yeah, and then I would add to that, I mean, it's a good framework. Number one, it's best practice. But as Kelsey said, even if it's not incorporated into your contract, that FAR 52203-13, it's a good place if you want to go back and get, there's even more detail probably than what we're putting in our presentation here. We will send this presentation out, by the way, as a link, so you can go back to it. But this is a good place to start to go through a real actual checklist. It's not particularly long. I printed it out. It's about 1 page, 1.5 pages back and forth. It's a good place to start. The other thing that it helps with is there's a pretty tight overlay between this provision and what the Department of Justice has in its sentencing guidelines. So for corporate sentencing for the Department of Justice, it follows a pretty similar track. And those are the two things we look at when we're on the enforcement side to say, what do we need to do to mitigate here? And so it's going to get you a leg up from a DOJ perspective as well. If, in the knock on wood, it won't happen, but from a mitigation perspective, it's helpful. So talk to us about what's in the code, Kelsey, and above and beyond just having the code itself. If you've got a code, what else should you be thinking about once you check that box?
Okay, so the code specifically, you're going to want to cover a lot of the things that we're covering here, and you're going to talk about the ethics and compliance requirements as far as engaging in government contracts. And it really should come from the top down, right? So management of your organization should really be the ones buying into this and pushing it down. And it's really supposed to embody, how we want to represent ourselves as government contractors. And doing business with the government, in receipt of taxpayer dollars. So that's kind of where it comes from. So once you have that code, that doesn't mean, you're good, it's all done, et cetera. As Chris said, earlier, that the code is just step 1. Step 2 and 3 is that you also have to have a compliance program, which includes trainings, and then an internal control system. And a big part of what 52203-13 requires is timely disclosures of certain violations of federal criminal laws, the Civil False Claims Act, and significant overpayments. This is the mandatory disclosure rule I mentioned before, and we're going to dive into this a little bit more on the next few slides.
Yeah, this is a big deal. And I don't know, maybe it's been 10 years ago, maybe 15 years ago, since the mandatory disclosure rule came out. It's a bit of an odd place for me, at least, to put the mandatory disclosure rule under the code. So I guess you can incorporate it into the code and say we're going to follow this rule, but really, in my mind, they're sort of two different things. Even though mandatory disclosure is tucked under the code, if you read it in the FAR. But a couple things on the code itself before we get into mandatory disclosure. Number one, Kelsey makes a good point with respect to management being a part of it. I think management should absolutely be, you can find, I probably have 10 or 20 of these things that I've saved that I think are good templates. So you can easily find something online or talk to somebody like me and get a pretty good form to start with to have a code in place. That's not hard. Most companies have codes in place. But when you're looking at it from a mitigation perspective, either from the Department of Justice or an Office of Inspector General or a suspension debarring official, it's going to be a much better narrative to show this is a code not only that speaks to compliance in general, but it speaks to our company specifically, our industry specifically. So it's an easy way to get 3 points, so to speak, to say we don't have just a generic, we're going to try to do the right thing, but these are areas that are specific to our company. And again, from a perspective of knowing what the answers are or knowing what the test questions are going to be before you actually have the test, I'm looking right now at FAR 9.4, different part of the FAR, but this is what governs suspension and debarment. So if there's a compliance issue, oftentimes you have an enforcement action or maybe just a contract administration action, depending on the severity of it. But either way, it could end up with a suspension debarment official, and you could be facing a proposed debarment from government contracting moving forward. Well, the FAR lays out a list of considerations that suspension debarring officials are supposed to take into account as they make a determination on whether or not to debar a contractor. There's 10 factors, and the first one, again, lines up perfectly with what we're talking about here: standards. Whether the contractor had effective standards of conduct and internal control systems in place at the time of the activity. Another one, a little bit further down the line, is full cooperation, and then timely disclosure. Whether the contractor brought the activity cited as a cause for debarment to the attention of the appropriate government agency in a timely manner. So again, most contractors have these as a contractual obligation anyway. But even if you don't, the reason it's a good idea is because if you are in the unfortunate situation of dealing with a debarring official, this is going to be literally the second question they ask, that they're directed to ask by the FAR. So let's talk about mandatory disclosure, Kelsey. What's it involve? What do you have to disclose and when?
Okay, so the mandatory disclosure rule, it's kind of what it sounds like. It mandates that you disclose to the government violations of certain federal criminal law, violations of the Civil False Claims Act, and significant overpayments. And you can see there on the slide that we have the regulatory bases for the rule, which comes from FAR 52-203-13, the clause we've been talking about, but it also comes from FAR 9.407 and 9.406, which, as Chris mentioned, has to do with suspension and debarment. To me, this is, I think if you're coming from the commercial sector and into government contracts, this is one of those things that, take a step back here. You are obligated to tell the government when you have credible evidence that your company or an agent or a subcontractor that you're working with has done something wrong. So you're self-disclosing, you're sort of telling on yourself, right? And from the government standpoint, you can see why this makes sense. Again, we're dealing with taxpayer funds. The government wants to only do business with responsible, professional, ethical businesses, et cetera. So in that sense, it makes sense. I think it's a little bit hard to swallow as a contractor that, I've got to sort of wave the flag on myself. But with that said, if you have this compliance program in place and the internal controls in place that we're gonna talk about, the hope is that you won't ever have to make a mandatory disclosure. You won't ever run into these sort of violations and whatnot. And so in this sense, you'd be okay. But it is a big deal. It's something to be aware of, and it is a tool at the government's disposal for sure.
And for those who aren't dealing in this every day, from a contractor perspective, it can be a little bit, it's a fine line between, do we have credible evidence, number one, and then do we report? And there's, keep in mind, we're thinking about this in two tracks from a mitigation perspective. I mean, first and foremost, we want to prevent it, of course, but in the mitigation context, we've got the enforcement side, which can be civil or criminal, but in general, you're not in the business of, and nor do you have to disclose some sort of criminal incriminating evidence against you. And so, in that sense, the instinct would be to bury it. On the other hand, though, you're dealing with debarment. Debarment, unlike the civil and criminal enforcement actions we've been talking about, does not have a general sense of a set of rules that relates to due process, but instead debarment, per the FAR, debarment is just basically a business decision by the government that it doesn't want to do business with a company because it doesn't find it presently responsible. So as a result, the debarring official can come back and say, we don't really care what the rules of evidence are. You still have to tell us what happened. And if you didn't, and we're talking to a debarring official, again, that's number 2 on their list. That's going to be a high hurdle to get over to convince the debarring official that we were in compliance with our program and following the rules, but chose not to disclose. So, and I also think it's important to note the breadth of mandatory disclosure issues. You think about things like fraud and conflict of interest, but any violation of False Claims Act really gets pretty murky. So I think it's important to have a full investigation first before you make a decision like that. We always encourage folks to either go through in-house, or sometimes it's a cleaner process to use outside counsel, but one way or the other, to have an attorney involved who understands how to work through internal investigations, who can preserve the privilege, the attorney-client privilege, and probably apply the work product doctrine as well, both to protect what that initial investigation was, and then to understand what then do we disclose to the government, because those may be two different things. And there's obviously a lot of strategy and sort of internal discussion that needs to happen in terms of what action do we take to run this to ground internally, and then what action do we take as it relates to the mandatory disclosure rule and any other obligations that may stem from the results of that internal investigation. All right, so Kelsey, can you give us some more details in terms of when and what we have to disclose?
Yeah, and I think you kind of hit on this. So I think, if you're going about business, right, and you start and you say you come across something that kind of, did we not comply with certain requirements here? Like, did we possibly, make some misstatements to the government, right? Like, say you uncover something that just doesn't feel right for your company. A knee-jerk reaction might be, oh my goodness, this is horrible. Like, let me look at the mandatory disclosure rule, et cetera. But, you can take a breath, take a minute, and remember that the requirement is to timely disclose when you have credible evidence. So what do these terms mean? Well, the FAR doesn't define either of the terms, credible evidence or timely, but in looking at the final rule, when the FAR Council created the mandatory disclosure rule, they talk about credible evidence as being a higher standard than reasonable ground to believe. And specifically, they said that this implies that the contractor will have opportunity to take some time for a preliminary examination of the evidence to determine credibility before deciding to disclose the government. And so when we think about credible evidence, you also consider it in terms of timely, or when you think about timely, you can consider it in terms of what is credible evidence. So the rule as published by the FAR Council is designed to give companies, contractors, time to take a preliminary examination, to conduct an internal investigation, to really assess, do we have credible evidence of a violation here, based on the facts, based on the regulations. So really the requirement is to take reasonable steps to determine whether or not you have something that you are required to disclose to the government here. So it's what's timely and what's credible, et cetera. The steps that you take, the reasonableness of it is obviously going to depend on the type of violation and the extent of the investigation required to determine whether it's credible evidence, et cetera. But the bottom line is, if you uncover something that might look bad, don't immediately freak out and call your contracting officer or the inspector general, et cetera. Take a minute, take a breath, assess whether what you've got in your hands and whether you really have credible evidence and whether you really have to make a disclosure.
You can see there's a lot of murkiness here, and the time to figure out what the internal process is going to be is not once you get evidence of a problem. The time is now to figure out, again, this is tucked under the first prong of the three prongs that we're talking about, the code of conduct. It doesn't necessarily have to be in the code of conduct, from my perspective at least. It could be an internal process, an internal memorandum. We'll get into the other two written products that you probably should have, and maybe it's in one of those two. But some way, shape, or form, there needs to be a process of who takes control of the situation, and what the next steps are, and and then you can look at some of these really highly specific legal questions about when and how to disclose, but there needs to be a process in place beforehand, not and sort of in the fog of war when you're trying to figure out, did we do something wrong? Is this a big there should be a process laid out beforehand so you know what steps to take, and then you can get to these tough final conclusions. And I'll just mention one other thing here, which is this is obviously compliant across the contract. There are a few things that do require that do have a set time on them, and the one that comes to mind, at least immediately for me, is the DFARS 252-204-7012, which is the cybersecurity requirements, which will, if you do DoD work, you know this already. Right now, you've got cybersecurity requirements. I guess in a year, I don't know when it'll happen, but soon there will be CMMC, which will be a third-party certification But in any event, among the requirements you have for DoD is to report a cyber incident, and there are specific timelines around that. So this doesn't necessarily apply to every issue that could come up, but I think the takeaway here is there needs to be a process in place, number one, and number two, there's some wiggle room in terms of how long it takes to go through that internal review process and then make a decision on the mandatory disclosure. Here are a couple of issues, and Kelsey, I'll just breeze through these because I think we've kind of talked about them. I don't want to hammer too much on all the bad stuff that could happen. I think, again, if you're dialed into this program, you probably know most of it already, but you hear the terms suspension and debarment. Just to be clear, again, if you're not doing this work all the time like we are, suspension is typically temporary, and it typically stems from a specific incident that feels like a compliance issue, i.e. company was charged with something, was indicted with something. On the other hand, debarment is final process. Those both come from the same office. Each agency has a suspension debarring official. Some agencies have more than one. For example, there's one for each of the branches of the military, and then certain agencies have consolidated in one suspension debarring official. So, but we use the rules for suspension debarment sort of as an overlay to the compliance rules, as well as the DOJ sentencing guidelines I mentioned before, to get a feel for what really is best practice. What are you going to need if this type of issue comes up in the future? And it also helps from a prevention perspective. So again, these are the sorts of things we're trying to avoid. And we'll now move on to the second and third prongs that we talked about at the beginning. So we've talked about the code of conduct and also the mandatory disclosure rule that's part of the code of conduct requirement under the FAR. And then we've got the next two prongs. The first one is an ongoing business ethics awareness and compliance program, which I've sort of boiled down to employee training. That's the thrust of what that requirement entails. And then the third prong is an internal control system. So we're going to now look at those two in turn, and let's start with the ongoing ethics and compliance program. Kelsey, before I turn it over to you, I will highlight the word ongoing. So I'm calling this employee training in general, but it's important to note this is, as with each one of these prongs, but this one in particular, this is not a one-time deal. This has got to be something that's really a regular, at least annual, I would say, but it's got to be a regular part of the contractor's everyday business, and that's also clear from the requirements that suspension debarring officials apply to these situations. So, Kelsey, talk to us a little bit more about this second prong and what's required here.
Yeah, so you're on, as Chris mentioned, ongoing compliance program. It really requires periodic communication and dissemination of information, and then periodic trainings. So what communication and information do I need to disseminate to my employees? It's the standards and procedures and other aspects of your compliance program and internal control system that employees need to know as far as their roles and responsibilities and how they're supposed to conduct themselves within the company and then while performing government contracts. The trainings themselves should also be periodic, and they should be to the company's principals and employees, and as appropriate, the contractors are agents and subcontractors. So note that it could expand outside just your specific organization.
Yeah, and there's sometimes some questions about what training is required. There's nothing more than what you see on the slide here. So there's a lot of discretion. We've got a few we've got a few slides at the end of this. If we have time, we'll get to that'll give you maybe some ideas. We have some stuff. I have some stuff I do whenever I do these trainings. But I would start with where do we see the highest level of risk. Then you can go through the back of your contract through each FAR provision. You'll see quite a few of these compliance issues that pop up. And so the good news is there's not a real prescribed way to do it. And I always think it's easiest in terms of a check the box process to have once a year, everybody comes in and hears from somebody who can speak to these things and give some real world examples. give some hypotheticals, because that, in addition to the mitigation side of it, to say we've done it, it also helps with the prevention side, to say these are things you may encounter, and then let's talk about it. Let's figure out what's the right answer. It also gives you a chance to communicate the first bullet on this slide, which is you need to not only have your code in place and a culture of compliance and doing the right thing in place, you have to communicate that to your clients, to your employees. And so doing an annual training where you've got a sign-in sheet and you can say, these are the people that attended. Oftentimes, one way to do it that I've done before is to do sort of an hour for everybody. These are things that everybody needs to know. We do business with the government, therefore, here's some high-level compliance things, and here's some scenarios to work through. And then to maybe drill down a little bit further for another hour or two with the folks that are on the front lines with the government more, especially business development, especially supply chain, and especially contract administration. Those are the people that, as well as legal, and maybe HR as well. But those are the folks who are kind of touching more directly some of these obligations. And so, that's an easy way to say we've done it this year, and maybe you combine it with some other corporate function that would bring all these people together in person or online. But it doesn't have to be that way. I've got a client does work in the kind of public construction, utility type work, and I've seen this with more than one actually, as I'm saying it now, where every meeting they start with, let's talk about safety, and there'll be we did it in the Marine Corps too. We did a safety brief at the end of, before every long weekend. And it can be a little bit rote and trite, but you're talking about safety a whole lot. You could do the same thing with compliance. You could be not that we have to get everybody together for an hour a year or for a day a year, but rather that for every meeting, so there's lots of ways to do it. It's not prescribed. And I think to the extent you cater it to your company, that's probably benefits. That probably shows a suspension barring official, an enforcement official from the government side. No, we take this seriously. If we had an issue, it was an employee that knew better, but chose to do the wrong thing. So it shouldn't impact the whole company. We're dealing with the employee, we're dealing with the situation, but we've got the program in place to show that our employees are well trained and know the right thing to do. All right, let's now talk about, so that was really all that we had, I think, on that training piece. Again, if we have time at the end, we'll go through a few potential topics you could cover in training and communicating to employees. Now we're on to the third topic, the third prong here, which is the internal control system. And this is the one that probably has the most moving parts to it. But again, a lot of things we can put in writing to document the company's doing the right thing. So Kelsey, can you walk us through the requirements for the internal control system?
Yeah, so there are prescribed minimum requirements that not only come from the FAR Contractor Code of Ethics clause that we've been talking about, but these also track from the DOJ sentencing guidelines that Chris has mentioned before. So these are the minimum requirements to have an effective internal control system. So at a minimum, the assignment of responsibility at a sufficiently high level with adequate resources to ensure the effectiveness of the program in internal control. So think of this as a compliance officer. There are some considerations for smaller organizations. You don't have to hire a separate individual, although you may want to. This can just be, the point is to charge someone with the overseeing and effectiveness of this program. You must also have principal screening, which so reasonable efforts to make sure you don't include in your organization individual as a principal whom due diligence would have exposed as having engaged in conduct that is in conflict with the contractor's code of ethics. So don't make a bad actor a principal of your organization. Do your due diligence, do a background check, confirm that this person is complies with your standards of ethics and conduct.
Yep, and then we'll move on, and I'll just beat a dead horse here to say all these things should be documented, and hopefully when you document it, it spurs action as well. But at a bare minimum, this is again where you can walk through the FAR requirements that we've got spelled out here, and put it in writing, because it's going to be a whole lot easier to explain the steps that the company took to be in compliance if you've got it in a formulaic document, as opposed to going back and saying, yeah, I think we did this, let's go back through emails and confirm it. So this best case should be in writing. All right, so continuing on through the internal control system, Kelsey.
Yep, and again, these come from the FAR and the sentencing guidelines. So periodic reviews of your policies, your procedures, your internal controls. Make sure that you have the right procedures in place to detect criminal conduct and obviously deter it, and assess the level of the risk of criminal conduct within your organization. You also need to have an internal reporting system to allow employees or others to report suspected violations of your code of conduct. It should allow for anonymity or confidentiality. So a hotline is often used here and is recommended by the FAR. You also need to make sure you have disciplinary in place for improper conduct, but also for failing to take reasonable steps to prevent or detect improper conduct. Your internal control system must require timely disclosure of what we talked about earlier, the mandatory disclosure rules. And it also must ensure that your organization fully cooperates with any government agencies through, if an audit is required or an investigation, et cetera.
Yeah, so this is seems like a lot of work, right? Especially for a small business. And we actually have a question on that, so I'll just address that now. It says small businesses and commercial item acquisitions are exempt from the compliance program and internal control system requirements. That's the question. And the answer is it doesn't hinge the requirement. The FAR requirement doesn't hinge on the size or type of procurement. It really hinges on whether or not that FAR clause is incorporated into the contract. So that's a pretty straightforward answer, to look for FAR 52.203-13 in your contract. Keeping in mind, oftentimes it is included on that kind of standard commercial flow down, where it's just a list of FAR clauses and one or more are checked. Oftentimes that one is included. So, and then the government's supposed to put it in at the thresholds we mentioned before. It's 120 days and 5.5 million, I think. And so that's kind of the black and white answer. But maybe the more important issue to keep in mind here is that, of course, there's not a bar on enforcement. The risk is not less for a commercial or a small business, a commercial provider or a small business. And so when it comes to avoiding the bad stuff, the first goal that we're trying to accomplish here, really these things can be incorporated even if you don't have the compliance requirements. But it is scalable. That is a good news, especially for small businesses and maybe for commercial entities that feel like they've got less exposure in this area. So Kelsey, talk to us about some of the ways you can cater this to specific industries, specific companies.
Yeah, so the sentencing guidelines specifically provide that the formality and scope of actions that an organization takes in establishing its compliance program depend on the organization's size and industry standards. So, for example, a large organization, it's reasonable to expect that you'll have more formal operations and greater resources dedicated to establishing and managing and overseeing a compliance program. Whereas a smaller organization, you're not going to expect the same level of resources and commitment to be put into it. With that said, the enforcement risk isn't waived just because you're a small organization. You still need to, especially if this is in your contract, need to have this type of internal controls, compliance system, et cetera. But you can meet the requirements with less formality than the larger organizations. So the sentencing guidelines specifically talk about training employees through informal staff meetings and monitoring through walkarounds, right? And they talk about maybe you don't hire someone completely new to be your compliance officer, but you have someone that serves, has a dual hat role that does your compliance, but also, is part of managing the company in other aspects. So I think before this is a lot of information and it is a lot of work, but just know that you don't have to go, crazy in establishing this compliance program. And then something that Chris had said earlier, that as far as even setting up a code of conduct, right? You can find something online as a good basis to start. And the sentencing guidelines even talk about, if you're a smaller organization, Have you modeled your compliance program and your internal control system after, maybe something that a large business has done or other successful, companies in this area? And sort of relied on what other people have done to set up your program. So you don't have to start from scratch, and you don't have to go super crazy here. Just take, what's reasonable, consistent with the size of your organization to make sure that you're just meeting these requirements, so to speak.
Yeah, and the sentencing guidelines, keep in mind the FAR does not draw this distinction. This is from the sentencing guidelines. So it's good to underscore the fact that you can meet a lot of the FAR requirements without necessarily taking the same steps that a large company would if you're at a small company. But you still, as Kelsey said, the requirements are still there. The other thing with respect to commercial companies, and we work with a lot of commercial companies who, the federal government is a customer, but they're selling the same good or service to the federal customer as they are to the commercial customers. So it can be difficult to think through, okay, so we've got, let's just say it's only 10% of our customer base, and yet we're going to go through this whole other compliance process, for 10% of our customer base. Is this worth it? And the answer, I think, in general, is you've got to check all the boxes, but you probably have checked a lot of those boxes already, especially the larger commercial companies. A publicly traded company typically already has a code in place, already has a pretty robust compliance process and program in place. And even if it's not directed to the federal customers necessarily, they've got regulatory overlays in a lot of those industries. They've got best practices for their shareholders. And so oftentimes it can be an exercise in going through what do we have in place already, and what can we use to check the right boxes for the FAR, so that if we have a federal issue down the road, we make sure we've done the right thing and we can mitigate that, and also, again, to prevent. But I would say there's oftentimes a 60, 70, 80% solution, maybe more, with the program that you already have in place, especially for larger commercial companies. But sometimes there can be a tweaking. You can add a page here or there, or a paragraph here or there. You can add to what you're already doing from an employee training and onboarding perspective. Let's add a government contract module and make that a part of our regular training base, and especially for the folks that are doing the federal work. So I think it's true with small businesses, but also with commercial companies, that this kind of scalability, this a way that you can make this applicable to your company without necessarily investing the time and energy that might seem evident on the surface. On the flip side, you are just a federal contractor and are doing tens, hundreds of millions of dollars of federal work in a given year. You would probably, the suspension to barring official is probably going to have a different expectation, and there's going to be something that's probably expect something that really is FAR based and focused on that. So the fact that you can adjust to only go so far, but I think it's an important point to bring up. So this is, I think, our last topic. These are some specific areas that we've seen problems on the legal side in terms of where do we see enforcement action, where do we see significant compliance burdens. This can also overlap, by the way, into what sorts of things should we train to. So when I go out and do these trainings, these are the types of things often that we talk about, and that are probably, most of it's applicable across the board. And so it'd be something that you train a wide swath of employees to. And let's walk through. So again, we try to do the headlines, but like real world, this is why it matters stuff. And Kelsey, maybe you can talk us through some of these rules, and then how we've seen them play out in the real world.
Yeah. So again, think about this really is like something that is specific to government contracts as it differs from commercial practices. So when you're working in the government, know that no government employee can accept any gratuity or gift from anyone, doing business with a government agency, which includes government contracts, right? So if you're in the commercial sector and you've got a client that you've, worked with forever, and, you want to buy them a nice bottle of wine or, a fancy dinner to celebrate, years of good business, et cetera, whatever, you can't do that in the government space. And I think that that's something that, especially for people that are, on the BD side of things, that this is a very real rule that we see a lot, that people, run up against. You can't do those sort of things that you're used to on the commercial side when you're in the government space. And there, this is a criminal statute that imposes, at least the bribery one, imposes criminal sanctions on both sides. So on the acceptor of the gift, the bribe, the government, and on the one, giving it out, so the contractor. It's also codified in the FAR, these principles as well. So anyway, it all goes back to what we've been talking about in the beginning, and the underlying theme of this is that you're doing work, you're performing contracts with taxpayer funds, and so everything just needs to be above board. You can't even give off the appearance of impropriety whatsoever. We included these recent headlines here. So, a businessman that gave bribes to city and county officials to obtain public contracts. Contracting officer pleads guilty to conspiracy to defraud the government. He used his relationship with a government contractor to hire to have them hire his friend as a no-show, receiving all this money, scripts, etc. I think when you read these are some sort of egregious examples, but just know that the rule is no gifts to government employees. Really try and keep things above board. Don't do anything that would even give rise to the appearance of impropriety is where we should start from.
Yeah, a couple more notes on that. I mean, obviously the government should be watching this as well. The government employees should as well, but there's bad actors on the government side, and people who aren't paying attention to details there as well. And obviously we're worried about the contractors and our own company. It's also a way to sort of show your maybe sophistication from a business development perspective. Hey, I understand we can't do this with you as our government customer. So let's create, sometimes you go to events and the government folks are expected to contribute to the meal that's provided. Those are the types of things that you kind of show you understand their perspective. So I think that's maybe a helpful tip. And then this idea of appearance of impropriety, it applies here. Obviously, you don't want to bribe government officials. I think that's not going to be a surprise to anybody. But when you look at government procurement, there is a sense of oftentimes these people, you work with them day to day. Sometimes you're working right next to the contractor, physically sitting next to a government employee and doing effectively the same job. And so you end up with some close interpersonal relationships. And of course, folks move from industry to government back and forth. So you see in the procurement process, when there's a solicitation, all of a sudden you have a contractor whose business development person is spending a lot of time with their government counterpart, and maybe that government counterpart is part of the evaluation process on the government side. So it may not be a bribe, but keep in mind you've got this broader issue of appearance of impropriety, and you may not get stuck with this rule in particular, but there have been a couple of bid protest decisions in the last year or two that have called this out, where government folks and industry folks who work together on a daily basis then get together socially, and there's talk about, well, was there discussion about the evaluation? Was there discussion about what should be in a proposal? This is the incumbent contractor. They're in cozy, well, a new contractor coming to the area is going to look at that and say, well, is the incumbent getting some sort of favoritism due to their interpersonal relationship with the government side? So it certainly includes the idea of not giving somebody money or something of value on the government side, but it can be broader than that in terms of interpersonal relationships. And so that's a real dicey area, and again, something to train to. It may not be always intuitive to contractor employees.
Chris, we have quite a few questions about that, as far as de minimis or allowable gifts to the government, or do we have any examples of things like dinners or happy hours of people getting in trouble? It's a challenge to get our business development folks to understand these things when they don't believe it'll result in real trouble, using vendors, et cetera. Anyway, so this might be enough can we provide a luncheon, for visiting government staff, et cetera. This might be a good topic for a follow-on webinar, especially as we only have 5 minutes left in today's presentation. But I don't know if you want to have any closing thoughts on that, or talk about discussions here and employment offers quickly at all.
It's a tough one, yeah, and especially when it gets into the de minimis versus, what is a trinket you can hand out at a trade show versus something of value that you send to somebody as an appreciation. And then, by the way, each agency oftentimes has its own internal gift rules. So, yeah, the gift issue with the government is a really tough one. In terms of an example, the one I just mentioned, I don't know if it's quite a gift issue, but that was an actual bid protest that went to the Court of Federal Claims, where there was a standing happy hour between the contractor, who was the incumbent on the solicitation, and at least one, and I think several of the government folks. And as it turned out, one of the government folks was on the evaluation team, and so there was the protest was that the incumbent had an unfair advantage. So that was an issue where then the incumbent won the award. The award was then challenged. So at a minimum, you're spending a bunch of legal fees going into the U.S. Court of Federal Claims to fight about whether this is a fair procurement or not. Worst case, you may end up losing the procurement over that, and probably the business development on the contractor side, you would expect may have gotten reassigned, so that incumbent could show we're doing this above board. If memory serves, I think the government folks may have also been moved to a different place. So that's a real world example of something that actually happened that is in the public record. And it is worth, if you've got business development folks who are doing this type of work with the government, it's worth having a very specific policy and a chain of command within the company. And I'll tell you, and it's true, by the way, not just on federal, but on state and local as well. We've got some of our state and local folks who work on this, and it's an actual area of the law that this is kind of all they do, because there's so many different rules across state and local governments and universities, and so just trying to maneuver through all that can be really challenging. So I think that's probably a high level, as much time as we have now, but it's a great idea. Maybe we'll do a follow-up on that, and certainly reach out to us when we send the link to the presentation. Respond, and if you've got specifics, and we can probably provide some more detail that might be helpful for you to have that internal discussion. Let's see. I'm just going to, because we have 2 minutes left, I'm just going to touch on a couple more of these. Procurement integrity is a really big one. Most of it's intuitive, but when you get in the hot and heavy process of trying to win a contract, and you're competing with kind of your arch enemy for the same government work, there can be some things that get kind of sloppy. And an example, the Procurement Integrity Act says if there's something that's procurement sensitive, the government can't give it out, obviously. But oftentimes it does happen. It happens more than I would have expected. That I get a call or an email, hey, the government sent out something, they accidentally forwarded us the other guy's proposal response instead of our proposal response, or they sent out a document they thought was redacted. I've seen that happen several times. Government thought they redacted it, but we can unredact it, and you have folks. So that feels like one where you've got to train to it, because again, an aggressive business development person in the commercial space is going to say, great, business intel, we'll take it. But on the government side, you can't do that. And not only can you not do it, is it a violation of the law, but there's kind of these long-term consequences. There's a case that went up to the Virginia Supreme Court where a company was got information they weren't supposed to. They went through several years of mitigating that and really trying to do the right thing to make sure it didn't happen again. But their business development people took the information, and there's a question about whether or not they used it. And then when they went to sell the company, that created a whole nother litany of issues down the road. So it's not, the big thing, of course, is avoiding enforcement and doing the right thing and preventing these issues from coming up in the first place. But it can have second and third order consequences that you don't consider either. All right, we are at the top of the hour, so I'm just going to get to the final slide here, which is this one. Our takeaways: remember the goal, prevention, and then mitigation. The three main requirements: make sure you've checked each one of those boxes and you've got it in writing. Important to get information, to get buy-in from leadership, make it a cultural issue, training, in general, training, and then focus on industry and size of the company. Make sure this stuff is documented. You will be glad you did it if you ever have to encounter a situation like Kelsey and I do on a pretty regular basis for clients where you're facing the government and trying to explain that you did the right thing. So we really appreciate you taking the time to attend. We will send this out as a link so you can have the slides and have the presentation if you want it later, and are always happy to talk further offline if you want to respond to that email. Thanks. Hope you have a great rest of the day.